Hey, welcome to the podcast. Sit back, relax. Try not to throw nothing at me because you won't hurt my feelings. You'll just hurt your computer. This podcast is brought to you by your host, me, Robert McCune. So, when the Supreme Court slapped New York around regarding the pistol permit process, which for the past 100 years was unconstitutional, and that the state couldn't ban guns from the entire state or a whole city as a sensitive place. So the next day, dumbass Governor Kathy Hochul released a press conference saying that the Supreme Court just took away New York's rights to restrict concealed carry and made New York unsafe. This Democrat, and yes, I do mean dumb, just doesn't get it. The Constitution was drafted to limit the government power, not limit the people. I'll tell you what, if she ever graduated from a law school, she should go back and hand her degree in because she definitely didn't earn it. She even went so far to say that the Supreme Court took her right as a governor away to limit the rights of the people of New York. Wow. Hey, dumbass. Yeah, you, Kathy. They couldn't take away something you never had. So what did this dumbass governor do? She consulted with every gun control group she could get her hands on. Just 8 days after the Supreme Court slapped New York down, what did they do? Enacted the most ridiculous law, pretty much banning all carry within New York State, directly defying the Supreme Court's, making the whole state a sensitive place. Well, if you've been following this Comedy Central shit show, a New York federal court judge ruled that this new law was pretty much unconstitutional and placed a temporary injunction on it, but gave New York time to appeal, which they did about 6 hours later. And that court date is set for later this month, which pretty much brings us up to current date. Today, a federal judge in Buffalo has temporarily halted the portion of New York's new concealed carry law that applies to houses of worship. A federal district judge, John, and I'm not kidding, his last name is Sinatra, said the grounds for his decision was the Supreme Court's precedent regarding the right to bear arms and the state's failure to demonstrate that such regulations is consistent with the nation's historical tradition. See, the Supreme Court really did lay the foundation here to dismantle all the gun laws on the books because the judges are limited to only rule in favor of the states if they can show that precedents of text, history, and tradition back in 1791. Basically, if they didn't have it then, you can't have it now. So the temporary restraining order granted by Judge Sinatra only applies to churches, synagogues, mosques, and etc. Basically, all places of worship, which were deemed to be sensitive locations under the Concealed Carry Improvement Act. The law made it a criminal offense to possess a gun in a place of worship or religious observation. Those locations were the focus of a lawsuit filed on October 13 by two Western New York pastors, citing the need to defend themselves and their parishioners should someone intend to do or cause harm. Pastor Jamie Hardaway Jr. of Trinity Baptist Church in Niagara Falls and Bishop Larry Boyd of Open Praise Full Gospel Baptist Church in Buffalo said in a court filings that the state's ban violated their Second Amendment rights. And apparently, a lot of judges agree with them. Today's decision will apply to other faith leaders and congregations across New York while the lawsuit plays out in the courts. There's also several other ongoing legal challenges to the state's new laws, which they all basically should win. But regarding this particular court case, all parties are scheduled to be back in court on November 3rd. Now, Erie County District Attorney John Flynn, whose office is a defendant in a lawsuit because they are tasked with prosecuting those who chose to break the state's new gun laws, as unconstitutional as they are, he says that he instructed police agencies to abide by this ruling. So that means for the time being, no one in Erie County will be facing charges in relation to carrying a concealed weapon or gun in any place of worship. I'll tell you, this Supreme Court decision, NYSERPA versus Bruin, man, that really set up a legal domino effect for all these gun laws. Federal judges have been striking down gun restrictions in the months since the Supreme Court decision that expanded the Second Amendment rights, and experts say there is likely a lot more to come. As examples, a judge in West Virginia last month cited the Supreme Court case when he struck down a federal law that requires guns to have serial numbers. So did a judge in Texas who ruled last month that people under criminal indictment can still possess firearms. Why, you might ask? Because they're only facing charges. In this country, you're innocent until proven guilty, and an innocent person is of legal age that hasn't committed a crime or proven to have committed a crime can still possess a weapon. And now, with longstanding partisan division in Congress over gun control bills, the Supreme Court likely will have the final say over the fate of the nation's gun regulations. And Judge Joseph Goodwin of the United States District Court for the Southern District of West Virginia notated in his decision about the serial number law, he referred to as Section 922K, that the Supreme Court didn't allow him to take into consideration other factors, such as the ability for law enforcement to solve crimes. Now, other gun rights advocates have filed lawsuits to challenge gun laws, such as a ban on the guns on the metro in Washington, a ban on homemade guns in San Diego, or the ban on assault weapons in Colorado. So, with the ripple of lower court decisions, might not legally, but practically force the Supreme Court's hand to weigh in again. Because in all actuality, the sweeping decisions could turn the federal firearms law into Swiss cheese, with some judges upholding regulations while others strike them down. And while those challenges play out in court, Congress and state lawmakers have little guidance on what'll pass constitutional muster, like they care anyway, or even know. And a law professor at the University of New Haven said that the Bruin decision and subsequent lawsuits will make it difficult for lawmakers to draft legislation that survives the Supreme Court review. And the professor said even if you can pass something that is very comprehensive, you may want to rethink that or think twice about it. Now, other proposals have stalled in the evenly divided Senate, including expansion of background checks more broadly, and an expansion of gun right forfeiture for people convicted of misdemeanors, domestic violence against, like, say, their dating partner. I'm not sure when this merry-go-round will stop, but one thing I do know for sure is it's going to be one hell of a ride. So stay tuned. I'm not going anywhere, neither should you. Stay safe, stay frosty, and I'll talk to you when I talk to you. So, this is the part I tell you to subscribe if you haven't done it. Give me the thumbs up and ring my bell so you get more notifications every time I put more content out. Have a good one.